late start. We're waiting for language services practitioner, and she's now in court.
Okay, thank you. Who would be interpreting? Okay, thank you, ma'am. It's fine. Mr. Ntanzi, you can, in the meantime, be seated. I'm going to deliver my judgment, which is in writing, and copies thereof will be given to you. It's not a long judgment, hence I did not prepare a summary. This is an opposed bail application which was before me on the 13th of October 2022. I could not allocate the matter to any judge to be heard in the month of October because the judges in my division were busy with matters allocated to them in terms of the duty roster. The duty roster does not make specific provision for a judge who would deal with urgent bail applications. I allocated the matter to myself and regret that I could not deliver the judgment earlier than I anticipated due to other urgent obligations that I had to attend to. The applicant is accused number 2 and is charged together with 4 other accused on 5 counts, namely murder, read with Section 15(1) of the Criminal Law Amendment Act 105 of 1997 as amended. And sections 92(2), 94, 256, and 261 of the Criminal Procedure Act. Being the charges of attempted murder, robbery with aggravating circumstances, as defined in Section 1 of the CPA, read with Section 51.2 of the CLAA, and further read with Sections 92, bracket 2, 94, 257, and 261 of the CPA. Other counts is unlawful possession of a firearm in contravention of Section 3 of Firearms Control Act 60 of 2000 and unlawful possession of ammunition in contravention with Section 90 of the Firearms Control Act. All the accused are in custody. The state alleges that the 5 counts were committed on 26 October 2014 at Vosloorus in the district of Boksburg. This is a trial of a famous professional soccer goalkeeper who was killed at the house of a famous singer's mother. The trial commenced on the 22nd of April 2022 and has been televised throughout the duration of the trial. The applicant has pleaded not guilty, and the state prosecutor has up to so far led evidence of some of its witnesses thus far in the trial. The applicant filed an affidavit and called one witness to support his bail application.
Ubize umfakazi oyedwa ke ukuthi azokulekelela kulesicelo sakho se-bail application.
Applicant is about 33 years old and stated in his affidavit that he was born at Nongoma in the KwaZulu-Natal province.
Uthi ke wena una 33 uzalwa kaNongoma eZA.
He was resident at Freedom Park location, phase 2 in a rented unit.
Uthi wena ukuhlala ke eFreedom Park ephase 2 lapho uqashe khona.
He was arrested on 16 January 2020 at his place of employment at Impala Mines in Rustenburg and was earning 10,000 per month.
Uthi wena ke uboshwa nge-16 January 2020 la usebenza khona eParliament eRustenburg.
He is the sole breadwinner and was supporting 10 family members consisting of his siblings, parents, and his 2 children.
Uthi ke wena uweke olekelelayo le ekhaya noma ubheke umndeni and then ke usupporta ke abantu abayi-10 abazali abantwana bakini nabantwana bakho abayi-2.
He hopes that should he be granted bail, his employer will re-employ him.
Uthi ke unethemba lokuthi uma ke inkosi enkantolo ke ingakunika ke noma ivumelane nesicelo sakho ungabuyela emsebenzini wakho.
After his arrest, the police took him to his parents' home in KwaZulu-Natal.
Uthi ke emva kwalokhu kushiwo then amaphoyisa akuthatha ke babuyisele ekhaya eKZN.
He confirmed that he went to school up to standard 8, grade 10. He further states that after his arrest, the police and the state have frozen his bank account.
Uthi ke wena ke ugcine ku-standard 8 noma ke ku-grade 10 uthi futhi ke ama-bank account wakho avaliwe noma okwamanje awasebenzi.
The applicant averred that the state's case against him is weak because he was not arrested at the scene of the crime, which was allegedly committed about 6 years before his arrest.
Uthi ke abashushisi ke abanalo icala noma icala labo ke ubufakazi babo ke akugcinanga ngakuwe ngoba ke wena uboshwanga la kwenzeke khona isigameko and futhi uboshwa 6 years sandlulile icala lenzekile.
Furthermore, an identification parade was not held. There is no identity kit and no firearms or ammunition which was found to be in his possession when he was arrested.
Manje ke uthi ke akwenzwanga ke nalento ke ebizwa ke i-identification parade noma nemikhomba parade and ayikho into abayithola kuwe njengobufakazi into efana nesibhamu noma ke income.
He has no previous convictions, no pending cases, and no warrants of arrest against him.
Uthi ke wena ke awunawo ke amacala phambili noma ke awukazi wento umthetho uthi ke alikho ke iphepha eligunyazayo ukuthi uboshwe njenge-warrant of arrest.
He has no traveling documents and no relatives outside the borders of the Republic of South Africa.
Uthi futhi awunawo namaphepha ovakashela ke kwamanye amazwe futhi awunawo nobudeni kwamanye amazwe.
He states that he has strong ties in the Republic of South Africa and he is not a flight risk.
Uthi ke konke okwakho kula eMzansi and wena awusuwumuntu ongabaleka.
If he is released on bail, he will not endanger the safety of the public and there will be no threat to public order.
Uthi ke uma ke inkosi enkantolo ingakudedela ngebheli futhi ke wena angeke ke uphazamise ubulungiswa ngaphakathi noma ke wenze inkinga ngaphakathi.
He will not interfere with the administration of justice nor intimidate any witnesses.
Uthi ngeke uphazamise ubulungiswa futhi angeke uthusele nabufakazi.
Mr. Bongani Ntanzi, being the applicant's witness, provided evidence that he is the applicant's sibling and is from KwaNongoma in KwaZulu-Natal.
Tshwala ufuna umfowenu umbongeni uchazile ke ukuthi yena ke umntanakini ubuya kwaNongoma KwaZulu-Natal.
He said the applicant is a breadwinner The witness stated that Kwanongoma is accessible, there is an induna, and the applicant is a breadwinner. The state opposed the applicant's bail application. Brigadier Detective B.N. Gininda from the South African Police Services states in his affidavit that after arresting the applicant and during the interview, the applicant raised an alibi defense relating to the day of the incident, the 26th of October 2014. The applicant stated that he was on duty at work. However, upon investigation, Mr. Melda of Sibanye Stillwater Mines, where the applicant was employed, said the applicant was absent from work from 26 October 2014 and only returned to work on the 2nd of November 2014. The Brigadier further said on 19 June 2020, applicant made a confession freely and voluntarily to a peace officer. He further said the applicant secured services of an attorney, and on the 24th of June 2020, in the presence of his attorney, he made a further detailed confession to a magistrate in Boksburg. The Brigadier further states in his affidavit that on the applicant's first appearance, he was legally represented and the court was not informed about the alleged assaults by the police or about the admissibility of the confession. He denied that the state applied for the freezing of his bank account as there was no reason to do so. He submits that the state has a strong case against the applicant. That the state has a strong case against the applicant. He further states that there is a likelihood of a conviction, and if applicant is convicted, he could be sentenced to life imprisonment. The life imprisonment sentence may cause him to abscond and evade his trial. The Brigadier further alleges that the applicant's address in KwaNongoma has not been verified and it would be difficult to trace the applicant in that area.
Uthi uBrigadier the address of ngayo eyale KwaNongoma azange bayibheka bayifaka isiqiniseko sokuthi ke i-address engempela and ke kuzoba nzima ukuthi ke bakuthole uma ke wena ungadedela bese kunyakana.
The Brigadier in his supplementary affidavit states that the applicant's legal representative gave him 2 addresses to be verified where the applicant would be staying, namely Kohlokolo P.O. Box 6080 Nongoma, 39 P.O. Box 6080 Nongoma 3950, and the other address is 20 Kingfisher Street, East Village, Carltonville. The code is 2499.
Uthi ke uBrigadier weluphanenge address uthole uphanenge address yaNongoma eFortlaville and then phane futhi ke address ese20 Kingfisher Street eCarltonville.
He said the first address cannot be traced and it is a postal address.
Leyo qala le kuthiwa ke i-address ke ipost ke kasi address abangafaka isiqiniseko.
At the second address, the applicant's cousin, Sibusiso Blessing Ntanzi,
Bathi ke le address ke bathi kuhlala ke ukazini wakho uzala uSibusiso Blessing Ntanzi.
and the property belongs to his employer, Sibanye Stillwater.
Kodwa ke akumuzi wakhe umuzi kaSibanye Stillwater.
Which is the place of the applicant's previous employer.
Kula nawo usebenza khona.
Applicant's cousin said he needs permission of his employer to stay with another person and he has no permission to stay with the applicant.
Uthi ke umzala wakhe uma ke kwenzeka kube nomuntu ufuna ke noma ofisa uba kuhlala naye kumele aqale ayafaka isicelo ubanikazi bendawo okuwumqeshi wakhe okwamanje akaphiwanga imvume yokuthi angahlala nomuntu.
This version of Sibusiso Blessing Ntanzi is confirmed in an affidavit dated the 5th of October 2020 attached as Annexure B and G5 to the affidavit of the Brigadier. He submits that there is a likelihood that the applicant may influence or intimidate witness. He states that applicant may undermine or jeopardize the objectives and proper functioning of the criminal system because he is a liar. He says that applicant lied in his affidavit about the assault. He does not mention that he approached the state to have the matter concluded in terms of Section 105 capital A of the Act. He further lied about the freezing of his bank account.
i-account yakho yasebhenki-ke imisiwe noma bayifrizile.
He said applicant has no valuable movable and immovable assets.
Kuthiwa-ke wena unazo-ke iy'mpahla-ke into enjengemoto noma yini.
He said applicant lied about his alibi defense and the address of the applicant cannot be confirmed.
Uphinde wakhamba amanga-ke ngokuthi-ke unaye umuntu ongasifakazela and then uphinde futhi waqamba amanga-ke ukuthi nange-address yakho.
The applicant is charged with at least 2 Schedule 6 offenses, namely murder and robbery with aggravating circumstances, counts 1 and 3 respectively.
Kuhloswa-ke amacala-ke akhulu kakhulu, kuthiwa-ke awela ngaphansi-ke komthetho lokuthiwa u-Schedule 6, cala lokubulala, cala-ke lokuhloma, noma-ke ukubamba inkunzi kuhlomile.
The onus rests on him in terms of Section 6011A of the CPA as amended to show on the balance of probabilities that exceptional circumstances exist which in the interest of justice justify his release on bail.
Manje-ke sekuwumsebenzi wakho ukuthi-ke wena-ke uke ukhipha ubufakazi obulungisa-ke inkosi enkantolo ukuthi-ke wena-ke kumele uyithole le bail.
Section 61 of the CPA as amended reads as follows. I quote, "An accused who is in custody in respect of an offense shall, subject to the provisions of Section 56, be entitled to be released on bail at any stage preceding his or her conviction in respect of such offense if the court is satisfied that it is in the interest if the court is satisfied that the interests of justice so permit."
Kuthiwa-ke wena-ke umsebenzi wakho-ke ukhipha-ke ubufakazi obuzenelisa inkosi enkantolo ukuthi-ke wena kwamele udedele
The applicant, together with other accused, appeared in the High Court for the first time on the 11th of April 2022 before Maumela J for trial.
Kuthiwa-ke wena-ke uvele-ke phambi kwenkosi enkantolo la e-High Court ukuqala bekunye-11 April 2022 phambi ku-Judge Aubrey.
The case is now partly heard.
Okwamanje icala seliyaxoxwa liphakathi nendaba.
When this bail application was heard, 2 police officers had testified about what they observed
Nkathi-ke kwenzwa-ke ukukhulunywa-ke lecala-ke kuwabizwe lobufakazi namaphoyisa ukuthi bachaze-ke ukuthi-ke baboneni bazweni
and what they did at the scene of the crime.
nokuthi-ke kutholakale ini noma batholeni athibiwa lakwenzeka ikhona isigameko.
When the police officers arrived at the scene, the perpetrators of the crime were not present.
Uma bafikele amaphoyisa-ke kuthiwa-ke bona-ke ababangi lecala bebangekho noma igebengu.
One witness testified that the applicant was in the house when the alleged crimes were committed.
Kuthiwa-ke khona umfakazi ofike la wachaza-ke ukuthi-ke ummangalelwa noma yena ukuthi namhlanje phambi kwenkosi enkantolo bekakhona kathi kwenzeka isigameko.
This witness testified that he identified the applicant as one of the assailants.
Kuthiwa-ke lo mfakazi-ke uthi omunye walabantu abangene endlini.
When this bail application was heard, the witness had not yet been cross-examined when this bail application was heard.
Manje-ke uma kufakwa-ke isicelo sale bail, lo mfakazi bebangakaqali-ke ukumbuza imibuzo.
And his identification is what is referred to as doc identification.
Manje yena ufakazi-ke lo bheka khona la e-court ufike nje wakhomba-ke ummangali
The trial court will deal with the reliability and credibility of his evidence. What the applicant has not clarified in his affidavit is that after he was arrested in June 2022, why is he only bringing his bail application now after the state has called 3 witnesses? He has been legally represented when he appeared in the magistrate's court. The applicant in his affidavit sets out what he regards as exceptional circumstances in paragraphs 8.1 to 8.6. He emphasized that he's been in custody since June 2020 and was not arrested at the scene of the crime. He further states that the trial is to be finalized after a long time because the state has a list of over 100 witnesses. The applicant does not clearly state what is his defense to the incident of the 26th of October 2014. He pleaded not guilty and exercised his right to remain silent. The applicant further states in his affidavit that he was assaulted by the police. The injuries that he sustained caused him to bleed and he was forced to make a confession. He said the police wanted him to sign the papers which were full of blood and he refused to sign. I assume that applicant's version is that the police wanted him to sign a confession which had blood stains because of the assault by the police. The investigating officer in his affidavit states that the applicant made 2 confessions. The first one on 19 June 2020 to a police officer and the second one to a magistrate in the presence of his attorney on 24 June 2020 at Boksburg Magistrates Court. The investigating officer further says that the applicant further made admissions to private individuals. The applicant in his affidavit mentions 1 confession and he states that he refused to sign it. Applicant did not attach the 2 confessions that the state alleges he signed so that it could be determined whether they are signed or not, or whether the signature has been forged. The documents would also show if they were blood-stained or not. Be that as it may, the trial court will deal with the admissibility of the alleged confessions. The onus is on the applicant to satisfy the court and prove on the balance of probabilities that there are exceptional circumstances justifying that he should be released on bail. Applicant filed an affidavit and only called one witness to submit oral evidence that they are siblings. In my view, the applicant should have foreseen that there would be material disputes of facts and should have led oral evidence which could be tested under cross-examination, or he should have made a detailed and clear affidavit corroborated or supported by other facts to strengthen his application. In S v. Spinner, the court said, I quote, "Obviously, an affidavit will have less probative value than oral evidence, which is subject to the test of cross-examination." In S v. Busak, it was said it must also realize that they do so at their own peril because the value attached to a written statement is clearly less than that of evidence under oath duly tested by cross-examination. In scrutinizing the provisions of Section 6011A of the CPA, the applicant should adduce sufficient evidence and satisfy the court that there are exceptional circumstances justifying his release on bail. I do accept that the applicant has children and relatives in KwaZulu-Natal. He does not have a residential place in Gauteng, and there is no evidence of where he would stay closer to the court, as he purported to prove that he stay in Gauteng. He did not state how much money he has in the bank, nor why he did not instruct his attorney to unfreeze his bank account. There is no evidence to show that he would be re-employed or would get a new job. He further stated that he has not paid his legal representative a cent. In S v. Jonas, the following was said regarding the term exceptional circumstances. The term exceptional circumstances is not defined. There can be as many circumstances which are exceptional as the term in essence implies. An agent I'll have to verify this code, but the case goes on further to say a terminal illness may also be regarded as an exceptional circumstance. It would be futile to attempt to provide a list of possibilities which will constitute exceptional circumstances. To my mind, to incarcerate an innocent person for an offense which he did not commit would also be viewed as an exceptional circumstance. Where a man is charged with commission of a Schedule 6 offense, when everything points to the fact that he could not have committed the offense, because he has a cast iron alibi, this would likewise constitute exceptional circumstances. In this matter, the state did not place any evidence before the court either opposing the application for bail or in rebuttal of the applicant's denial of the commission of the offenses with which he had been charged. Yeah, I'm quoting what has been said in this case that I'm quoting. The court went further to say it would appear that the state had adopted this line of approach on the assumption that the appellant had all to do in order to succeed with his bail with his application for bail. Now, in this case before me, having considered the evidence before me, I'm satisfied that the applicant has not discharged the honors to prove exceptional circumstances, that exceptional circumstances exist, and that it would be in the interest of justice to grant bail. Will you please stand up? The application for bail is dismissed. You know that as I was reading my judgment, there are some typos which I'm going to fix, and you'll only get the signed judgment after I shall have fixed those typos. Court adjourns.